Namaskaram. Myself is Dr. SONI. I am an advocate and a corporate lawyer. Today we will discuss right of accused to give representation. If you are accused, the primary trouble is that how to interact with police or CBI or ACB or vigilance. Because in the course of interaction, we are having multiple questions without a choice. Simply we have to answer. There might be a possibility of pressure, threat, compulsion, coercion, but despite of that we have to answer. The same may result even in the illogical explanation, and the said approach might further implicate us in bitter legal consequences. So, the representation is an important document to mitigate or parry all the said legal troubles. If you want to have legal troubles, then you may follow your path. But if you want to avoid or parry the same, in that scenario, the present video is practical in its approach. Basically, we have to understand the key aspects of representation so that we could represent our case effectively. The first criteria of representation is to follow the following diagram. Basically, this diagram is taken from a book named as Principle of Management, in which it is specified that if you want to work on a case, you have to follow a path. That is operational research, number 2 managing, number 3 defense strategy. The orthodox pattern of us is that simply consult a lawyer, give your case and he will defend. The approach is wrong. You have to work out on your own case. If you are not working on your case, simply you are depending on a lawyer, you cannot win. For this, just read the report or FIR. There will be multiple facts. Some might be true, some might be false. Find out the facts which are false so that you could answer them. For this, you have to do the operational research. For this, you have to collect the raw material to be answered, the corroborating or consistent evidences to be enclosed to sustain the fact that you are innocent. For example, if the concerned complainant submitted that a certain work is pending with you, but you are having the contrary evidences with you that the work is not pending, in that scenario, you may submit your representation with that point. In case the concerned authority is not going to work on it, it would be a case of unfair investigation. Ultimately, it will infringe Article 21 of Constitution of India and you will get the benefit. And the sad point is uncontroverted to be noted that in one of the case titled as Pramod versus State of Jharkhand, the accused was caught red-handed, but he specified that there is no pendency work and that's why there is no motive or re-award, and finally he got a discharge. Judgment date is 16th of November 2022. So basically we have to work on a theory, we have to follow the principle of management so that we could have a proper defense strategy, otherwise it would not be possible. The primary step is that we have to find out our raw material, find out the point of consistency, corroboration, and then we have to find out the legal principle and have to apply the same to find out a proper defense strategy. Do you know, if you are not having a proper defense, in that scenario you could not be succeeded even though prosecution is false. And we got more trouble in case of section 7 or section 11 of PC Act because there is an adverse presumption of section 20 of PC Act. So in that scenario, we have to work out on the theory of probable defense in the trial. For this, we have to set up a defense strategy, defense theory to work out on our case, otherwise we would not be succeeded. Now the important question arises how to prepare the representation. For this, we have to follow the certain key aspects. Number one, to engage a lawyer or expert. To be noted that if you are not having any acquaintance with the legal proceedings, in that scenario, it is advised to have a lawyer. Even though you are not having a lawyer, you may avail the facility through legal aid, because it is duty of the concerned state to provide you the lawyer even through a legal aid. For this, you may peruse Article 39A of Constitution of India, Section 303, 304 of CRPC, so that you could have the systematic, logical, legal answer to the questions of prosecution. The said protocol is sine qua non to protect any prejudice to your rights. To be noted that even you are having the right to keep the lawyer with you at PS in case there is a case of arrest or custodial interrogation. You may take the legal advice and even could keep the advocate with you during the course of interrogation, although not during the whole interrogation. So basically, what you are doing, you are going to protect your rights, and that's why the proper representation is sine qua non, so that we could have logical side on the record. And apart from that, the said representation entirely helps you to understand about your rights. For example, I want to share one of the most important case study. To be noted, judgment is pronounced by Honorable Rajasthan High Court in Rani Dhan versus State of Rajasthan. Judgment date is 8th of October 2024. In said case, it is specified that if the case is confined up to the extent of demand only, 17A of PC Act is imperative if there is no prior approval from department. In that scenario, the proceeding would vitiate and the accused could avail the benefit of question. For example, if the accused is not going to have the proper representation, do you think would he be able to understand about his rights? Answer is no. To understand about your rights, the representation is sine qua non. Apart from that, you could fight your case in a strategic way. It is going to provide you strategic input. For example, you are going to consult with a lawyer or expert. Inter alia, you are about to know about your case. You are about to know about your rights. You are about to know about your obligations. You are about to know the duties of consent IU. And apart from that, by having the logical answer to the submissions or averment in the FIR, definitely you could represent your interest in effective way. Basically, by the virtue of representation, we are going to compel the police do investigation not only from side of prosecution but also from side of defense, so that you could submit a neutral report before the concerned court. As we know that it's a duty of the concerned police is to do investigation. In the course of investigation, it is seen that the facts of defense is not taken on record, by the virtue of which you could put up your defense in a strategic way and could protect your right from being prejudiced. Apart from that, it entirely provides you the protection in case you are arrested. For example, you entirely consulted with a lawyer and have the representation, and finally it is submitted even though you are arrested. Now your family is going to consult another lawyer. So the defense prepared in a strategic way would help the lawyer to have a proper bail application without any conflict. And apart from that, you could defend your case at trial without any worry. Because when the document is submitted, it is not considered. In that scenario, you may put up question to TLO or IO. Regarding the non-consideration, in case they fail to answer, then it would be a case of unfair investigation, and finally you could get acquittal. Judgment title is Vakil Prasad versus State of Bihar. Judgment date is 23rd of January 2009, to be noted. So we could say that the representation is important. Basically, it provides a safeguard to your rights. It ensures that your rights are not allowed to be violated during the police questioning. Apart from that, it helps you to understand the legal process, your rights, your obligation, their duty, and apart from that, with the help of lawyer, you could prepare a strong defense strategy so that if you're going to fight the case, even though for questioning, discharge, trial, in that scenario, you could have the effective case and could represent your rights in a fair manner. We all deserve the fair proceedings, and that's why to ensure the fair proceeding, representation is must. And you could give the same. Now I am coming on the practical way how to submit the representation. For this, you have to consult a lawyer to prepare the draft. But before doing the same, prepare brief at your own level, collect corroborating and consistent evidences at your own level so that the strategy could be proper. After having the proper draft, we are supposed to send it through mail, through WhatsApp, through post to the concerned authority so that it could be on record. In case they deny that the document is not received, in that scenario, with the help of the said instruments, we could have the benefit. To be noted that if it is through electronic means through mail or WhatsApp, in that scenario, a certificate under section 63 of BSA is required along with hash value. So in this way, we could represent our interest and could have an effective representation so that we could defend our rights in effective way without any prejudice. I think that I'm totally able to cause all of you to understand the importance of representation. See you in the next video. Till then, Jai Hind, Jai Bharat.